Does it look like I've got the?
Thought something was wrong on my end. I just emailed Mick. All right, I'll take it back.
Hello, everyone at home. Can you hear me?
Yeah,
Okay. How is everybody?
okay.
All right. Um, Today, obviously, we have finished up free speech and we're moving into the two religious clauses, the free exercise clause and the establishment clause. Before I get there, we found out yesterday, we have our faculty meetings every Monday at 8 a.m. on Zoom. And we found out yesterday that there are going to be no live exams this semester. So on Tuesday, the 24th, 2 days before Thanksgiving, the exam will be given remotely to everybody. So we're keeping the major exam, I guess, and not just having one big final. We're breaking them up. And nothing has changed except for the fact that you'll be taking it remotely. The first exam will be for classes 1 through 16. Now, I am also told that there have been enough glitches in the new software that we don't feel comfortable using it for the first exam. And I don't know how this is going to work, but we're supposed to monitor you taking your exam on Zoom while you take your exam. The way that it will work, I guess, is, and I'll have to get out some written instructions on this. I gave last year's property exam on Twen, and instead of posting it as a quiz, I post it as an assignment, and you download it. And then what you do is you just type up your answer. And for those of you who have an accommodation where you don't type, we'll deal with that. Don't worry. That'll be accommodated. But what you do is most of you type, and it worked out really well last semester. You just, when you're done, you upload your answer into Twen, and it comes in anonymously, just like all your quizzes and the like come in anonymously. And there are supposed to be proctors who will be watching you on Zoom, so you have to put yourself on Zoom. I have no idea. Has anyone taken an exam yet where that has happened?
Yes,
Has
evidence.
it worked okay?
Yes.
Yeah.
Coin is at its best, is flipping through it.
Yeah.
Carrying through the exam.
Okay, so I guess I had heard a lot of complaints from students about this new exam software, how hard it was to deal with. And I guess the administration decided it just didn't want any major incidents happening, people being deprived of the ability to do well on their exams. I think the plan is still to use it for the final in December. But I think there's a lot of work to do in getting it ready for everybody to do that. And what I did last year, and it worked out pretty well, was before the real exam, I just sent out like a little silly test exam to everyone. And you typed in like Mary had a little lamb, and then you uploaded it type thing. Just so that everyone sort of got the feel of being able to do that on Twen. I think what you'll see is when you do them as assignments instead of as quizzes, it'll be a little bit easier and less stressful to deal with. Because what happens is I get a timestamp. It doesn't shut you out automatically, but it will record what time that you uploaded your answers. And that way, if there are glitches, we can deal with the glitches. If they come in a few minutes late, and you have an explanation, that's fine. We'll deal with that. And I'm of the mind frame to be more forgiving than usual when it comes to these types of things. The pandemic has caused everything about legal education to be topsy-turvy. Obviously, it seems every week there's a new change in how we're going to do the final exams. And I apologize for that. That's more stressful from your end than from my end, and I get that. Obviously, we're going to do our best to make sure that everyone has a fair shot at being able to submit the exam as they normally would. Okay. And as I say, it did work out pretty well in property last year, so we can do this. Yeah. No, I think I'm going to do, I was planning on doing an hour and a half for each exam, but I'm going to do, I think, 2 hours for each exam instead. And they're not going to be comprehensive. So the first one before Thanksgiving will be classes 1 through 16. And then the second one will be classes, I think let's see, today's 23. We're in pretty good shape here, believe it or not. So I have one on Thursday, which is 24. I have one a week from today, which is 25. We will get 27 classes in, okay? If I can't get everything done in 27, I'll do an asynchronous class where I would just put audio onto a PowerPoint presentation. But I think the way we're going here, I think we're in excellent shape to get everything done in the 27 classes, okay? Sorry, another surprise. I expect the administration will be putting something out in writing, and I certainly will be putting something out in writing for you guys. I'll probably send you an email blast, just letting you know everything. Okay. All right. Let's what's that song by REM? Finding My Religion, Losing My Religion. Let's find my religion instead of losing the religion today. We'll start with the free exercise clause. So we're going to get through the free exercise clause relatively quickly here. There are essentially 2 cases on the free exercise clause that you have to worry about. Sherbert versus Werner, and Smith versus Employment Division. For some reason, I think Chemerinsky puts them backwards. Sherbert was the older, more classic rule, and I'll do that case first. And then the Smith versus Division of Employment, or is it Division of Employment versus Smith? I never remember. Is 1990 case that came later and that changed everything. But we still have to learn Sherbert because in response to Smith versus Employment Division, Congress went and passed the Religious Freedom Restoration Act, which we call RFRA. RFRA is what people call it. RFRA is the Religious Freedom Restoration Act, which essentially reimposed by statute, reimposed the Sherbert test that we're about to get, okay? So it won't take us long to get through those. And then we're going to look at one RFRA case, which, was a big case when it came down. It was all over the news and everyone remembered it. It's the Hobby Lobby case, okay? And it's going to, right now, religion is a little bit up in the air. So we'll address some of that as we get through it. And then we'll be done fairly quickly with the free exercise clause. The establishment clause is a little bit more complex than the free exercise clause. But I'll break that down into a methodology for you, and we should be able to finish that up today as well. Now, once again, there are multiple cases on religion that I could do, but I don't have the time to do here. I do them in First Amendment law. I teach that in the spring, so that's an elective. A lot of you won't be taking First Amendment law. So it's important that I cover this stuff here, because you're gonna get a free exercise question and an establishment clause question on the bar exam. Perhaps even two of each. I can promise you that they will be tested. Okay, so let's start with sort of the old classic rule. Obviously, freedom of religion is a very, very important individual right, and the Supreme Court treated it that way, and essentially in this Sherbert versus Werner case, established a strict scrutiny standard of review. So Ms. Sherbert was a member of the Seventh-day Adventist Church, not to be confused with Jehovah's Witnesses. They are two different sects. I believe both, however, are Sabbatarians. And you guys know what a Sabbatarian is: someone who celebrates the Sabbath on Saturday rather than Sunday. Okay. The Jewish religion has a strong Sabbatarian custom. Jehovah's Witnesses do, and Seventh-day Adventists do as well. And the more orthodox style of these religions, truly believe that you don't do anything on the Sabbath. So, for example, the Puritans were Sabbatarians. On the Sabbath, they weren't even able to ride their horses to church. They would have to walk to church because they didn't want to be working the horses. And I don't know if you know this or not, there was no cooking on the Sabbath. And this is how New England baked beans were invented. They would be put into that crock the night before, and they would be cooked slowly for hours in the wood oven. And the embers would still be warm when they got back from church the next day. And they wouldn't have to cook. They would just, they'd be already cooked, and they'd take the beans and eat the beans.
Jews still do that, by the way. Orthodox Jews do stuff Friday night, crock pots, and they don't even flush the toilet on Saturday.
Okay, I can buy into the first one.
Well, it's an electric thing, whatever. Go ahead.
I don't think my family would appreciate the second one.
Yeah, 2 generations ago, and some still don't. I'll let you continue.
So, Ms. Sherbert, obviously, as a fundamental tenet of her religion, couldn't work on Saturdays. Her employer, who was a private employer, did not accept this and fired her. She couldn't find another job, and so she applied for unemployment compensation from the state of South Carolina. The state of South Carolina apparently did not think that she should be excused from working on Saturdays, found her religious justification to be unacceptable, and ended up denying her unemployment compensation. The case went up to the Supreme Court. And first it went to the South Carolina, the Supreme Court, which said to Ms. Sherbert, screw you, you lose. And then, of course, it went up to the United States Supreme Court, where the court, right here on this slide number 6, the court creates the so-called Sherbert test. If a person demonstrates a sincerely held religious belief, the government must demonstrate a compelling governmental interest to uphold the restriction on her religious practice or practices. Okay. Now, just a couple of quick things here. In regard to the sincerely held religious belief, the court is going to pretty much accept the testimony of the plaintiff as to whether they are sincere or not. The court is not going to second guess and superimpose its views, on sincerity onto plaintiffs. That's number one. Number two, I think you've seen this from a couple of previous cases. The religion does not have to be a mainstream religion. Okay. And someone, we've already looked at the Summum religion, and I spend a lot more time talking about that in my First Amendment class. You know, how they mummify people when they die, and they mummify pets, and they have odd symbols, and it seems to be a unique mixture of um, Egyptian and Indian cultures with it. There's the so-called Baba Louie case, which we don't get to in this class, is about the Santeria religion, and they do animal sacrifice in some of their religious practices as well. So I think the point I'm trying to make here is the Supreme Court is not going to. Oh, by the way, did you guys hear this? Someone told me this about 2 or 3 years ago in class, and I actually looked it up. There are people who like worship pasta, and they wear like colanders on their head. You know, like the colanders that you drain pasta in on their head.
Sure, the pastafarians.
The
Yep.
pastafarians, yeah, there you go. And literally, the Supreme Court is just going to say, if you believe it, you believe Scientology, for example, gets protection under the First Amendment, both free exercise clause and free speech clauses as well. Okay, so you know, don't get into, well, that's not a real religion, they're not being sincere, that's a bunch of crap. Don't get into that at all. The Supreme Court's going to just accept, you know, whatever comes before it in that regard. So as long as it's a sincerely held religious belief, South Carolina must demonstrate a compelling governmental interest, because there's clearly an interference, a regulation, or a restriction on her religious beliefs. She's being forced to choose between being gainfully employed and practicing her religion. South Carolina cannot come up with a compelling governmental interest to justify this rather harsh rule. And so they fined for Sherbert in this case. And that was the law for a long time, from 1964, 1963, until 1990, when, see, I always flip the defendants and plaintiffs. It's not Smith versus Employment Division, it's Employment Division versus Smith, essentially. And you guys know that the appealing party is always listed first in the Supreme Court. Okay, in Massachusetts, you keep the same case name throughout the entire system. So if you file in the Superior Court, Smith versus Jones, it stays as Smith versus Jones, even if Jones appeals, okay? When you're in the United States Supreme Court, the party appealing, the appellant or petitioner, is listed first, okay? So here, obviously, the Employment Division lost in the circuit court down below. And the reason we'll see in a minute that the Employment Division lost was because the circuit court was applying the Sherbert test. But this case, Employment Division versus Smith, essentially reverses, overrules the Sherbert case and dispenses with Sherbert as our test in most circumstances. So this is an interesting case. A couple of guys in Oregon who worked for a drug rehabilitation organization. They were Native Americans, and as part of their Native American religious activities, ingested peyote. And I don't even know how you ingest peyote. I don't know if you eat it. I don't know if you smoke it. I don't know if you liquefy it. I don't know. Little liquid in a bowl that you have to drink. Okay, there you go. So as a result, they get fired from this drug rehab outfit. I guess they figured they didn't, even if it was done for religious reasons, they didn't want people who were ingesting peyote working at a drug rehab place. And they, just like Sherbert did, this is almost the exact same case as Sherbert. They filed for unemployment compensation, and they were denied. They were denied because their dismissal was justified as work-related misconduct. And the case comes up before the United States Supreme Court. Justice Scalia writes the decision, and he overrules Sherbert. Sherbert is no longer the test for free exercise cases if the law in question, and they almost always are neutral laws of general applicability. In other words, they don't facially regulate religious practices. They're usually criminal laws, or they're usually unemployment laws, that deal with when you can and cannot qualify for unemployment compensation. If it's a neutral law, and clearly, if we apply Sherbert in this case, these guys are going to win, right? Because peyote is a part of their religious practices, and the government has to come up with a compelling governmental, justification for denying them unemployment compensation. And unless they can show, that somehow they put people at risk, it's hard to come up with a compelling governmental interest. These guys are going to win under Sherbert. But the court now is saying, no, this is a neutral law of general applicability. The Controlled Substances Act of Oregon has nothing to do with religion, it's neutral. And the unemployment compensation laws deal with misconduct generally, not misconduct as a result of practicing one's religion. So these are neutral laws of general applicability. They apply to everybody. And so the result is that those laws are going to be upheld unless the government singles out religious behavior for punishment or was motivated by a desire to interfere with religion. So the plaintiffs have to make a pretty strong showing here under the now under the free exercise clause of the First Amendment in order to claim that the free exercise clause has been violated. What does this do essentially? It makes it very, very difficult to bring free exercise cases, okay? And I think you've seen from a lot of our free speech cases that we just finished up that a lot of them involve the practice of religion. And the reason for that is because of employment division versus Smith. It's hard to win these cases. So what do people do instead? They say, well, there are free speech rights involved in the practice of my religion. It's easier to win on the free speech grounds than on the free exercise grounds. So they bring them primarily as free speech cases. This, makes free exercise almost impossible to win, except that Congress was a little bit upset about the division, the employment division versus Smith case. I think they saw that states could be creating these secular laws. A secular law does not involve religion. Secular laws that are essentially, harming the ability of people to practice their religion freely. So they passed the Religion Freedom Restoration Act, or as I told you, you can call it RFRA, which essentially just reinstated the Sherbert test. It said if there's a sincerely held religious belief that has been restricted or interfered with, the government has to come up with a compelling interest in order to have that law not stricken as applied to the person whose religion was interfered with, okay? And then using RFRA, we have Burwell versus Hobby Lobby Stores, Inc., a 2014 case. I had never heard of Hobby Lobby before. I don't think they're real big in New England, but this is a huge, huge business. And apparently they're all around the country, and it's someone explained to me arts and crafts type things. It's a privately owned corporation, huge corporation financially, but a privately owned corporation. It's a family-owned business, so only a few members own the stock in it. And they are evangelical Christians who own the business. And so the Affordable Care Act, one of the provisions of it was to make contraceptive care available to women. The Affordable Care Act does not, require that abortions be paid for, but it does require that a lot of contraception be covered. There are some exceptions to this, almost entirely for religious organizations. So, for example, if you work for Catholic Charities, you're not gonna your health plan will not cover contraception. I can tell you that right now, because it's against the religion of the Catholic Church for that to happen, despite the fact that virtually everyone uses contraception these days. So there's sort of this open debate as to, what is an abortion and what isn't an abortion. I think I'm oversimplifying the question. But a lot of evangelical religions and a lot of mainstream religions as well believe that life begins at conception, okay? So contraception that works after conception, that's a mouthful. Contraception after conception, and there is contraception that works after conception. To them is wrongfully killing a human life. And so these folks had provided health insurance for their employees. Now, because they don't fit within one of the exemptions, they're not a religious institution, they're a for-profit corporation. They're a closely held for-profit corporation. And I assume you know all about a closely held corporation. You guys have had business entities at this point. So they challenged the law. They wanted to be exempted from it. The Department of Health and Human Services regulations did not allow them to be exempted from it. So they brought suit under RFRA and under the Free Exercise Clause, seeking to enjoin, the requirement that they provide health insurance that covers this type of contraception as well. It's a fairly complicated fact pattern. If you read it, they're not opposed to all contraception. It's just this particular type of contraception, which they think is the equivalent of murder, essentially. If we apply Employment Division versus Smith, this is an easy one. Is the Affordable Care Act a neutral law of general applicability or general application? Yes. It applies straight across the board to everyone and to all employers, okay? And it doesn't deal with religion on its face. So under Employment Division versus Smith, Hobby Lobby loses. This is a pretty easy one. But what about RFRA, which essentially took the Sherbert case and revived it? So again, Hobby Lobby is not a free exercise case. It is not a First Amendment case. It is a statutory case under RFRA, under which Congress, apparently unhappy with what the Supreme Court had done in Employment Division versus Smith, went out and enacted a statute giving more religious freedom rights than the Constitution provided, okay? Now, as a baseline question, the Constitution establishes minimum individual rights for people. Can Congress pass a law enhancing those rights, giving more rights? The answer is yes, of course it can. And that's how RFRA is justified here. We're giving more religious rights than the Supreme Court has given, at least under the interpretation of Employment Division versus Smith. Now, this case came down to the fact that the government argued that, you know, there really shouldn't be religious rights for corporations, and certainly not for for-profit corporations. Those are sort of given up when one takes the corporate form. And the court here said, well, the statute seems to use the same type of person that's used in the procedure sense. So it seems to apply to corporations. Furthermore, all corporations really do is protect the rights of people associated. I mean, all individual rights do is protect the rights of people associated with the corporations. The court, and this was the most controversial part of this case. The court literally says that, at least in the case of closely held private corporations or other business entities, they have, a free exercise rights under RFRA that they can exercise, that a corporation can exercise. It's kind of an interesting concept because you've never gone to church or to temple or to mosque and sat beside a corporation, have you? I mean, you sit beside people while you're doing your religious practices. And it also, opens up another interesting question, and these cases are starting to come forward now. The baker who didn't want to make a wedding cake for the same-sex couple that was getting married because it violated his religious sensibilities. The Supreme Court decided that case without deciding it under the Free Exercise Clause or under RFRA. It ended up ruling for the baker and remanding the case to Colorado because he didn't get treated all that fairly, and they thought that the baker should have a better hearing. Essentially, that there was anti-religious bias on the part of the state. So it's going to be an interesting area to see how that expands. And I think the current makeup of the court you're going to see is with 6 conservatives, most of whom are Roman Catholic. Gorsuch isn't, but Roberts, Thomas, Alito certainly are. Sotomayor is Roman Catholic, but she's obviously not conservative. So I think you're going to see some expansion of religious freedoms under this current court. And people who don't want to cut someone's hair because they disagree with his sexual orientation, I think you're going to see this court moving in a direction of protecting the religious rights there, which is a really thorny issue, a tough issue to deal with, because obviously, if I'm allowed to exercise my religion so that it interferes with some individual right that you have, then how do we decide which individual right is more important? And does it come down to that the employer always wins and the employee doesn't? I don't know. It's going to be interesting to see where we're going here. Okay. So Sherbert is gone, but been resurrected statutorily. And it's awfully hard to win unless you can bring your case within RFRA. It's awfully hard to win these free exercise cases under Employment Division versus Smith. Okay, everyone okay on that? That's not so bad. Okay. Now the Establishment Clause gets a bit more complicated, unfortunately. It's because the members of the Supreme Court have wildly different views. Oh, I'm going the wrong direction here. Wildly different views of how the Establishment Clause should work. And quite frankly, the framers of the Constitution had pretty different views as to how the Establishment Clause should work. If you read the Establishment Clause literally, the clear purpose of it was not to have an official religion of the country. We're one of the relatively few countries that doesn't have an official religion, right? Most of Europe, at least until recently, most of Europe had religions, Anglicism in England. Obviously, the king or the queen is the head of the church under the Anglican religion, which is Episcopalian in the United States. And, Lutheranism, which is one of the Protestant religions, and then Catholicism. And each country seems to have its dominant religion, but not in the United States. We never really have had a dominant religion in the United States. And the framers of the Constitution, quite frankly, had very different, thoughts on religion. Some today we would probably call agnostics, who at the time were called deists instead. So you'll see that George Washington, Thomas Jefferson didn't claim to practice any particular religion. They just called themselves deists. Thomas Jefferson believed in the so-called strict separation theory of the Establishment Clause. To the greatest extent possible, keep the government and religion separated from each other, okay? Government is secular, religion should be kept out of government and left to the private realm of society. Some saw this important to protect religious liberties. Roger Williams, for example, the guy kind of started out Rhode Island. Didn't want the government to taint religion. Thomas Jefferson viewed this in the opposite way, which was he didn't want religion to taint the government. Thomas Jefferson, as I've mentioned, was not the most religious guy in the world. And he in fact wrote a letter to a minister of a Baptist church, which is a very famous letter now, if you study this stuff, where he talked about the strict wall of separation between the church and the state. This is not particularly a popular theory of the Establishment Clause among the current members of the Supreme Court, okay? The second one is the so-called neutrality theory, which is the theory that is used in the first case that we're going to take a look at, the Allegheny County case, in just a second. Government must be neutral on religion. It can't favor religion over secularism, or it cannot favor one religion over another religion, or it cannot favor secularism over religion, for that matter. Government's goal is to neither encourage nor discourage religion. In a lot of the cases that are in your book that we're not going to get to, you'll see this in the first case that we're about to do, but there are a bunch of other cases as well. A lot of them use this so-called symbolic endorsement test. And in the Allegheny County case, Justice O'Connor wrote the plurality decision. The whole idea is just how much does the government embrace a religious object or a religious belief? If it's pretty clear that the government is embracing it, then it violates the Establishment Clause, okay? If it symbolically endorses a particular religion, or if it generally endorses either religion or secularism, it would violate the symbolic endorsement test, okay? And then finally, I'm gonna guess that this is the approach that we're gonna be watching develop. This was Justice Kennedy's approach, the so-called accommodation approach. The accommodation approach recognizes that religion has always been important in American society, and the courts should accommodate its presence in the government, okay? So the only time the Establishment Clause is violated under the accommodation approach is when the government literally establishes a church, coerces religious participation, or favors one religion over another, discriminates against religions, okay? So that takes pretty strong government action. And one of the big cases, and they love to put this case on the bar exam, Lee versus Weissman, 1992 case. Here at a high school graduation ceremonies in Rhode Island, the principal invited clergy, local clergy, in to give the invocation at the beginning of the commencement ceremonies, and would rotate between the various, a priest, a rabbi, a minister would rotate between the various religious institutions that were there. And Justice Kennedy wrote the opinion saying this violated the Establishment Clause. It violated the Establishment Clause because it coerced religious participation. So he recognized that high school seniors who are graduating are under great pressure to attend their commencement ceremonies. Their parents want them to go, their friends want them to go. There's obviously a lot of pressure to be there. And once they're there and the religious practice starts, they're obviously under substantial pressure not to get up and leave because somehow they're offended by the prayer or the invocation that is coming forward. So while the practice did not establish a church, and it didn't favor one religion over another because there was a rotation of religions, Justice Kennedy said that it coerced religious participation, okay? And so that practice was deemed a violation of the Establishment Clause. So this is a good case to have in your book, County of Allegheny versus ACLU, Pittsburgh chapter, because it actually illustrates the different approaches. This is a plurality decision, so there's no strong majority on it. There's a majority in the result, but not in the reasoning, so to speak. It shows you how some of the different justices approach this. So in the city of Pittsburgh, in downtown Pittsburgh, has anyone ever been to downtown Pittsburgh? I have. How is it? I'm not a big fan of Pittsburgh. It was I thought it was a little run down. But this was a few years ago. In public buildings in Pittsburgh, one of which was the Allegheny County Courthouse, there is put a creche. And I believe this is an actual photo of that creche that's set up on the so-called grand staircase of the Allegheny Courthouse. Now, for those of you who aren't Christian, a creche is a depiction of the manger scene, the birth of the baby Jesus manger scene, okay? Clearly a religious depiction. Those who are Christians, Christ is at the center of the Christian faith. Therefore, the creche is celebrating the birth of the Savior, okay? The second scene is right here down below. And by the way, I've never seen Hanukkah spelled that way, but that's the way it is spelled in the case. I usually see it with an H at the beginning, but that's the way it was spelled in the case. So I
You can
just took it
spell
out
it
of there.
either way. You can do
Okay,
it either way.
that's what I figured. That's
Okay.
what I figured. So here you obviously see, if you can see at home, the cursor, a menorah, which is right next to a Christmas tree. And over here is a sign saluting liberty, okay? All of these are challenged. Well, not all of them. The sign saluting liberty is not challenged. But here you have a clearly Christian symbol. A Christmas tree is technically a pagan symbol, but it's been adopted as a Christian symbol. And obviously the menorah is representative of the Jewish faith. Everything but the sign saluting liberty is challenged. So strict separation approach, three of the justices, Stevens, Brennan, and Marshall. These are guys, Stevens came a tad bit later, but Brennan and Marshall were members of the Warren Court, a very activist court. you can see these folks taking the strict separation approach. They would ban both the menorah and the creche and the Christmas tree. Okay, all three of those. They would say, no, those are religious symbols. Kennedy, Rehnquist, Scalia, and White. Byron White, I probably mentioned him before, was appointed by John F. Kennedy. He was liberal in some respects and conservative in other respects. We'll see in equal protection that he did a big case, wrote a big case, Washington v. Davis, which we'll be talking about probably on Thursday. These guys are big on religion, and they wrote from the perspective of the accommodationist approach. The tiebreaker here was Blackman and O'Connor, and O'Connor wrote the decision, and she applied the symbolic endorsement test, which he says essentially is that clearly the creche was all by itself and was clearly a religious object. Therefore, it appears to be government, symbolically endorsing religion, and particularly the Christian religion. Gotta go. But she said it's a little different with the menorah and the Christmas tree, because first of all, it's not adopting any one particular religion, number one. And number two, it's on display with a sign saluting liberty. And so she didn't think that those displays went far enough in being a symbolic endorsement of religion. So she allowed the menorah and the Christmas tree to stay, but the creche had to go. Kind of like splitting the baby, so to speak, in the decision. Now, I will tell you quickly. There's two other cases buried a bit deeper in the book that we're not going to get to here, that I do in First Amendment, and they involve the 10 Commandments. And on one of them, the 10 Commandments is right in a courtroom, so that literally, as people are being sentenced, or their cases being tried, they're looking right at the 10 Commandments. Using this symbolic endorsement test, that is deemed to violate the Establishment Clause, because here you are with justice being dispensed, and there's a religious a monument or symbol that's being placed front and center, essentially. At the same time, there's another a case where the 10 Commandments are placed on the grounds of the state capitol building in Austin, Texas. It's not along a main walkway. It's sort of over in a quiet, grassy area, and people can walk over and sit on a bench and look at them if they want, but you're not forced to walk by them every single time you come into the Capitol building. And a lot of people claim that they walked by this and never even knew it was there. In that case, again, using the symbolic endorsement test, the Supreme Court said that does not violate the Establishment Clause. And the reason for that is, once again, there's not enough putting it front and center to make it look like a symbolic endorsement of religion, of the Judeo-Christian faith, so to speak. So that one was allowed to stay, was not a violation. Okay. Now, there's essentially two ways. Okay, so those are your different, this case is sort of a background case. It's going to show you the different approaches. I think you're going to be seeing, given this Supreme Court, the accommodation approach is going to become the most used approach to the Establishment Clause, okay? But here for the bar exam, here is going to be your methodology in dealing with Establishment Clause cases. There's two ways you can violate the Establishment Clause. One is to discriminate among religions, to choose one or some religions and give them favorable treatment over other religions, okay? That's easy. You can see if a religion is being favored by a particular law, or particular presentment of an object or whatever. And obviously the government is going to have to come up with a strict scrutiny justification, a compelling governmental interest, which is very, very difficult to do. Stupid. They don't want to go out and write a law that facially discriminates because the law is going to be shot down. But if they want to favor religion, they're going to be a little bit more subtle, nuanced about it. So they'll do it in a way that does not create facial discrimination among religious groups. If that's the case, if there's a law that is claimed to violate the Establishment Clause, okay, we are going to apply the so-called Lemon test, Lemon versus Kurtzman test. So let's start with I think a case or two involving discrimination among religions, and they're fairly easy to spot. And then we'll jump to the Lemon situation. We'll actually look at the Lemon case. So Larson versus Valenti, there's a Minnesota law, and it had these kind of onerous registration and reporting requirements. It required religious institutions to give a whole bunch of financial information, fundraising information, and the like. Kind of a burdensome thing for these organizations. What it said was, however, if you receive more than half of your financial support from members' contributions, you don't have to engage in this reporting requirement scheme, okay? So, you know, I mean, if you go to church or if you go to temple or, you know, the sort of mainstream religions, you know that each church or parish or temple is essentially financially supported through donations of the members. Some churches tithe, you know, other churches just pass the collection plate or the collection box, or what have you. These are the so-called established churches. So the court here says, look, you know, the Catholic Church easily meets this 50% requirement. A lot of the Protestant churches and the temples are going to, the Jewish temples are going to easily meet this 50% requirement as well. They're going to be exempted. But some of these sort of non-standard religions, these alternative religions, you don't see them around as much. But back in the day, the Moonies would be one of those religions. They're not going to raise as much money from donations, and as a result, they're going to have these onerous reporting burdens on them. And so the court says that this is clearly discrimination among the religions. The favored religions don't have to do the reporting. The disfavored religions do have to do the reporting, okay? So that's a discrimination situation. And I don't have another case. There are a couple of more cases in your book, but I've just chosen to give you a couple of representative ones. So if there's no facial discrimination, then you go to the Lemon versus Kurtzman test. We can call this the Lemon test. Here's the Lemon test right here. Number one, does the statute have a secular purpose? If not, it's unconstitutional. Secular means non-religious. So does the statute have a non-religious purpose? If it doesn't have a non-religious purpose, if the statute is only to restrict religion or enhance religion or discriminate against religion, then it violates the Establishment Clause. You don't have to go any further, okay? If it's a secular law, is the law's principal or primary effect one that neither advances nor inhibits religion? Okay. The primary effect, is it aimed at either advancing or inhibiting religion? And finally, and this is the one where we tend to come down to all the time under the Lemon test, does the statute foster an excessive government entanglement with religion. Now, this is obviously a bit subjective. What's an excessive government entanglement for strict separationists is very different than accommodationists. Would you agree with me? Okay. And in fact, the late Antonin Scalia used to bitch out the lemon test all the time, mainly because of this entanglement requirement. Okay. And so you could see the accommodationists not really liking this lemon test. And I've been telling students, you know, if the Supreme Court goes conservative, that we may be seeing the lemon test go by the by. I kind of doubt it's going to happen before you graduate from law school. So you probably don't have to worry about it for the bar exam, but I think eventually you might see that happening, because it looks like we've got a pretty solidly conservative Supreme Court, and it's going to be that way for quite a while, quite frankly. Here's what happens in the Lemon case. There are a couple of consolidated cases involving Pennsylvania educational systems and Rhode Island educational systems. Look, let's talk about the secular purpose behind this law before we get into it, behind these laws before we get into them, okay? It's really good for states to encourage people to get good educations and to be able to go to a good college, because those kinds of people tend to make a lot more money than people who don't get good educations and don't go to more recognized colleges. And when you live in a state and you make a lot of money because you're highly educated, you're going to pay a lot of taxes to the state. And you're also going to contribute to the intellectual culture of the state, you know, as well as the arts and, you know, some of the other important parts of the culture of the states. So there's really good reason to want people to be well educated. And we're lucky, we live in the Northeast where, you know, typically we're very well educated people here, okay? So Pennsylvania has a program where it reimburses non-public elementary and secondary schools for teachers' salaries, textbooks, and instructional materials. They're all secular books, but it's essentially a governmental giveaway to schools, at least some of which are religious schools, parochial schools, okay? And again, there's a secular purpose behind this, which is you want to make sure everyone gets a good education, even if they're not going to a public school. We want the populace to be educated, okay? Rhode Island just gives a supplement to non-public school teachers of their incomes. They supplement the income that the religious school pays them, the parochial school pays them, by 15%. So obviously, again, at least partially a secular purpose here, because, you know, if you want good teachers, good qualified teachers to be teaching all kids, and these parochial schools can't pay the teachers enough to, you know, to keep them, they end up going somewhere else, then the kids are going to suffer and not get as good an education. So you can see the sort of the reason why this is not discriminating among religions. Number one, it's not discriminating among religions because it doesn't favor any one over another. It's all non-public schools, both secular and non-secular public schools. And number two, there's a pretty good secular purpose behind it of a full education. The Supreme Court here says that the big problem is, well, Supreme Court says this one's no problem. This one's all set, okay? There is a secular purpose, a good education for all kids in the state, good secular reason behind that. The Supreme Court skips over number two to get to number three, because remember, if you fail any one of these, then it's going to violate the Establishment Clause. Go straight to number three and says, this is too much. This is an excessive entanglement. The cumulative impact of the entire relationship arising under the statutes in each state involves excessive entanglement between government and religion. In order to determine whether government entanglement with religion is excessive, we examine the character and purposes of the institution that are benefited, the nature of the aid that the state provides, and the resulting relationship between the government and religious authority. Here, in order to distribute these materials or subsidies, the state is going to have to get involved in the details of administration of these religious institutions and finds this to be an impermissible degree of entanglement, okay? So again, this is a fairly subjective test. That's one of the problems that some of the Supreme Court justices have with it. And the other is it doesn't necessarily adopt the accommodationist viewpoint that they would like to advance. We are done with the First Amendment, another big turning point in the class. The rest of the semester will be on two things: the Equal Protection Clause and the fundamental rights, so-called fundamental rights, okay? I think we'll be done with the Equal Protection Clause by a week from today. We'll start it today, get, partway into it. Probably get most of it done by the end of class on Thursday. And then what's ever left, we'll finish up on Tuesday and head for, obviously, Thanksgiving break. You guys have your exam. Oh, no, next Tuesday is our last class. A week from today is our last live class, right? Then we come back from Thanksgiving, and on, I think it's the 1st and the 3rd, we have 2 more classes. And then we'll be done at that point. Those classes obviously will be virtual classes. They'll be remote. And what I'll do is I'll do them at the, there you go, Happy Hanukkah. I'll do them at the same time as we would normally do them. So I'll do one at 12:30 and I'll do one at 9 p.m. at night. I'll do them on Zoom as if you're in the same room with me. Did you ever wonder what I look like without a mask? I think I did 1 or 2 classes without a mask, didn't I? You remember last semester, obviously. So yeah, have you ever heard I've got a face for radio? Well, I've got a face that's well suited to a mask. So all right, let's start out on the Equal Protection Clause. Now, the good news here is you've had a little bit of an introduction to the Equal Protection Clause because we went through the scrutinies when we did the 11th Amendment, okay? Equal protection of the laws means that the government will not discriminate against people. The first thing you have to realize about equal protection is that it involves classifications. Classifications are the government dealing with classes of people differently from each other, okay? Now, the problem is that not all classifications are bad. Some classifications are actually good. Sometimes you want to treat people differently in order to help society along. So the example that I give here is, if you think about it in the strict sense, if you have to be, I guess in Massachusetts, 16 and a half years old to be able to get your driver's license. In New Hampshire, a little looser up there. What do you guys get your driver's license at 6 or 7? It's what you can learn how to drive at 15 and a half and you get your driver's license at 16. Is that right? So no learner's permit. You just start to drive with your parents or whomever, and then you get it. Well, I raised 3 boys, and they're a little too precocious for my taste sometimes. And I could see my oldest is a lawyer, so he's a jerk. And no, he's not. I could see him raising the argument, why do I have to wait until 16 and a half to drive? That's age discrimination. And it is age discrimination, isn't it? You're classifying by dividing people up into groups by age, over 16 and a half, under 16 and a half. and you're telling the ones who are under 16 and a half that they are not allowed to drive an automobile. On the other hand, there's some pretty good reasons for that on top of it all, right? I mean, quite frankly, having raised 3 boys, I think the age maybe should be 30 for boys to be able to drive a car. You know, obviously you need to physically be able to drive a car. You have to be tall enough. You have to be able to reach the brake and the gas pedal, okay? You have to be able to shift the car, to steer the car, and, you know, all that kind of stuff. Probably most importantly, however, is you don't necessarily have the judgment to drive a car when, you know, until you reach a certain level of maturity. And so, you know, 16 and a half seems to be that sort of level of maturity that we require. That's not the kind of law we want to strike down under the Equal Protection Clause, although it's literally classifying people on the basis of age, okay? So the trick is, there are some classifications that are good for society. There are some classifications that are counterproductive to society, especially considering the history of racism and discrimination that we've shown in this country, okay? So you want to outlaw, under the Equal Protection Clause, you want to ban the bad discrimination, but you want to keep the good discrimination. And I suggest you don't use the word discrimination, you use the word classifications, okay? So that's what, you know, that's where we start with, a classification. How do we determine whether it's a good classification or a bad classification? Bad classification obviously being one that's unconstitutional under the Equal Protection Clause. And this is where our 3-tier system of review comes in. The scrutinies that we talked about starting back when we did the 11th Amendment, okay? There's, mentioned already, there's a hierarchy of these standards. Strict scrutiny is the most difficult standard for the government to be able to satisfy. It applies to the most serious cases of discrimination. Rational basis is the level of scrutiny that applies to those cases where we don't really think it's discrimination. It's okay to discriminate on the basis of age when you're going to get your driver's license. Don't people over a certain age have to go in for eye exams every time they get a driver's license now too? You know, it's obviously you don't want people who don't see very well driving around in a car, right? And usually that's something your eyesight diminishes with age. Those types of things are fine. And we're going to see that age is thrown into the rational basis category, whereas you know what goes into strict scrutiny, right? Here we go. You know what it is? Race, national origin, and alienage. I'm going to tell you right now, alienage, sometimes, not all the time, okay? More on that later. And the other thing is fundamental rights, okay? So strict scrutiny is fundamental rights in classifications based on race, national origin, and alienage. This is your test. It's tough to satisfy. Who has the burden of proof for enhanced scrutiny? The government. What must they show? A compelling justification. Additionally, the law must be narrowly tailored and must employ the least restrictive means of achieving its goal. There's got to be a very tight fit between the goal and the means used to achieve it. It shouldn't be under-inclusive or over-inclusive, okay? Second one is intermediate scrutiny. Here, it's almost always gender. It's possible it will apply in the non-marital children situation. We used to call that illegitimacy. It's not a very politically correct phrase these days. Here, it's not a compelling governmental interest. It's not that hard, but it's an important governmental interest. And it doesn't have to use the least restrictive alternative, all it has to be is substantially related to the asserted interest, okay? Intermediate scrutiny is also enhanced scrutiny. So if it's, those are the big ones again that we learned in 11th Amendment, right? Race, fundamental rights, race, national origin, alienage, gender, non-marital child status. Those are the enhanced scrutiny ones. Everything else is rational basis. Economic classifications are rational basis. Social classifications are rational basis. Age falls into rational basis, okay? Essentially, the argument here is age discrimination does exist, but guess what? Everyone hopefully is going to get old, right? And who's running the world? Old white guys like me, essentially, right? And so that's not the type of class that needs protection from anti-discrimination laws, okay? Non-fundamental rights, so-called liberty interests, we'll talk about some of those later on. We're going to see, for example, do you have a constitutional right to an education? The answer is no, not under the federal Constitution. A lot of states do. New Hampshire has a constitutional right to an education. Massachusetts has a constitutional right to an education under their state constitutions, not under the federal constitutions, okay? But economic classifications and social classifications will fall into rational basis. Here, this is a really forgiving standard. The government almost always wins. We're going to talk about a couple of cases where the government doesn't win fairly early on here. But most of the time the government wins. The burden of proof is on the plaintiff. The person challenging the governmental action has to prove a lack of a relationship between any conceivable government objective and the means employed to achieve it. So you've got to show pure arbitrariness. The government action must be arbitrary and capricious in order to be shot down. It's got to be utterly irrational in order to be shot down, okay? And as I like to say, this is proving a negative. There's no conceivable justification that I can think of for the government to do this, okay? It's got to be done for discriminatory means, therefore. And again, lawyers get paid to come up with reasons for this. So a government lawyer is going to be able to come up with a justifiable reason for the law. And you only have to have one reason, okay? And it doesn't have to be a perfect reason. We saw from the Williamson versus Lee optical case, similar standard. It's even if the court would disagree with the way that it's being done, it's not going to substitute its judgment for that of the legislature. And once again, these are essentially paying homage to separation of powers. The court does not want to become a super legislature. So when it comes to economic and social policy, the court's going to leave that to the legislature. That's what the legislature does. Only when it comes to important constitutional rights, race, alienage, national origin, fundamental rights, gender, it's the only time the courts are going to superimpose their judgment for the legislatures, okay? All right, let's start out with rational basis. At least get a little bit into these today. The justification under rational basis is always going to be police power, health, safety, welfare, morals, aesthetics. If the town is doing police power, masks up, please. I'm going to get yelled at if you guys don't have your masks up. The governmental power that's always going to be used is the police power, and the police power is very broad. Okay, Now look at these cases. These are flawed government laws. And the court is upholding them, saying that they don't discriminate, okay? And that's why you're going to see two things happening. One is these laws are under-inclusive, and two, these laws are over-inclusive. But if it's rational basis, the courts don't care, okay? So the first case is Railway Express Agency, Inc. versus New York, 1949 case. New York has a traffic ordinance. It says you can't have commercial ads on the sides of vehicles that are driving around in the streets. In the old days, it used to be literally that someone would take a trailer and put up a billboard on it, and then plaster an ad onto each side of the billboard and just drive around New York City all day, you know, showing the billboard and putting up the ads. So New York City said, you can't have an ad unless it's an ad for your own business. If you're doing an ad for someone else's business, you can't have it. If it's for your own business, you're okay. Okay. And how does it justify this law? To prevent distracted driving and to enhance the traffic flow. Do you see the flaw with the law? Okay. If I'm going to be distracted, does it have anything to do with whether the ad is for my business or someone else's business? A distraction is a distraction is a distraction, right? Okay. So there's really a logical flaw with this law, except that the court says, so what? The ordinance is valid. It's not being shot down under rational basis. You don't have to solve the whole problem at once under rational basis. Any improvement, no matter how incremental, is enough under rational basis, okay? It is no requirement of equal protection that all the evils of the same genus be eradicated or none at all. A city is free to ban some advertisements that distracted pedestrians without having to eliminate every distraction. It's okay to take one step at a time under rational basis, even when the scheme is flawed as a result, okay? See how forgiving this is? Government's going to almost always win. Now let's look at, instead of being under-inclusive, let's look at going a little bit too far here, okay? New York City Transit Authority versus Beazer. So kind of cool to be the good part about being a lawyer is that you learn about a lot of other things, you know, so like how to deal with drug addiction, for example. You get to learn about that by reading some of these cases. And one of the ways you deal with drug addiction is through the use of methadone. And I guess methadone is able to curb the, you know, the cravings and the needs that are provided by injecting heroin, which is a very highly addictive drug, obviously. But it doesn't give you any of the bad effects that heroin will give you. And I never knew this until I read this case, but apparently methadone is a fairly effective treatment for heroin addicts. They sort of substitute the methadone for the heroin. And after about a year, the strong majority of patients who have been on methadone maintenance for at least a year are free from illicit drug use. So it's, you know, it's sort of substituting one drug for another, but one of the drugs doesn't have all the bad effects that the other does. Personally, I wouldn't want one of my transit authority drivers driving around, driving a bus with me in it, if they're on heroin, would you? I could see that as a dangerous situation. On the other hand, apparently it's not a big deal if you're treating with methadone. So New York City, nevertheless, has a policy that it refuses to employ any persons who use methadone. This is challenged, given the same facts that we just, you know, talked about. People on methadone who have been on methadone for a while are almost always, the strong majority, they're not drug users. So the claim here is that this is overshooting. This is coming up with a remedy that's too extreme for the situation. Is classifying on the basis of whether one uses methadone a racial classification, a national origin classification, an alienage or gender classification? No. So it's not going to be strict scrutiny or intermediate scrutiny. It is a social classification, so it's going to be rational basis. And so the court here says New York can do this if it wants. Okay. Um, uh, uh, this policy does not circumscribe a class of persons characterized by some unpopular trait or affiliation. It does not create or reflect any special likelihood of bias on the part of the ruling majority. No matter how unwise it might have been for the transit authority to refuse employment to individual car cleaners, track repairmen, or bus drivers simply because they're receiving methadone treatment, the Constitution does not authorize a federal court to interfere with that policy decision. Again, this would be a legislative decision for the courts. Okay. Now, once in a blue moon, the rational basis will be used to overturn a statute. And I have two cases here for you where that is done. Okay. Sometimes this is called rational basis with bite. The court is pretending to use rational basis, but it sort of isn't using rational basis. Okay. So again, remember that the government almost always wins on rational basis, but here are two cases where the government loses on rational basis, and we'll end the class here after the second one, the Romer versus Evans case. The first is City of Cleburne, Texas versus Cleburne Living Center, Inc. Here, this guy, Jan Hanna, buys a building in the city of Cleburne. His intent is to lease it to the Cleburne Living Center, and they are going to run a group home for intellectually disabled adults, both men and women. So they're told by the city that they have to go in and get a so-called special use permit under the zoning regulations. They're told, this is not my language. This is obviously the kind of antiquated language. They're told that since they're going to be constructing a hospital for the insane or feeble-minded or alcoholics or drug addicts, or halfway houses for penal correction institutions, that they're going to need one of these permits. They go in to get the permit. They are denied the permit. They are denied the permit on three supposed grounds. Number one, the negative attitude of the neighbors. Number two, there's a nearby junior high. Today we would call those elementary schools. You know how junior high or middle school kids, did I say elementary schools? I meant middle school. Sorry about that. You know how middle school kids can be, and they're going to harass the residents of the group home. And then number three, the group home was located in a floodplain. Okay. Well, it doesn't matter that the nearby junior high school happens to have 30 intellectually disabled students right there. And it doesn't matter that all the houses in the area are in a floodplain and they're allowed to exist. But these seem to be valid reasons in the mind of the board. I have a feeling number one was the biggest reason. The NIMBYs, you guys know what a NIMBY is? Not in my backyard, right? Everyone thinks group homes are a great idea, except when they're in my neighborhood. And they come out of the woodwork to oppose those types of situations. The court said, look, there's no rational justification for what they're doing. This is just pure discrimination. And if they're mean-spirited, if they're motivated by discrimination, even under a rational basis, we are going to shoot down this law. The negative attitudes of neighbors is not even a real reason. the negative attitudes of neighbors might be discriminatory. That's no reason to justify a particular law. And I've already pointed out the other issues here. Romer versus Evans. The citizens of Colorado found it in their best interest to adopt this amendment number 2, which said that no judicial, legislative, or executive action can be used to protect persons from discrimination based on their homosexual, lesbian, or bisexual orientation, conduct, practices, or relationships. So what it does is it essentially takes away all of the already existing protections that LBGT folks have. And it says from now on, you don't get any and the government is not allowed to help you. Does that sound a little mean-spirited to you? Anthony Kennedy wrote the decision, and it sure sounded mean-spirited to him. Anthony Kennedy would be the judge who would write the Obergefell case. Obergefell was the case that said that not allowing same-sex couples to get married violated the Equal Protection Clause. He used rational basis just as he's using here. What does this case tell us? Last case, Cleburne tells us, what is the standard for intellectual disability or other disabilities? Strict scrutiny, intermediate, or rational basis? Rational basis. Okay, but if it's a mean-spirited law, it's going to be shot down even there. What is the standard for sexual orientation? Rational basis. But what Kennedy's doing here is applying rational basis with bite, okay? And he's saying, he's looking at the mean-spiritedness here. He says, here, we're not going to uphold a law if it disadvantages a specific group, as long as it can be shown to have a legitimate governmental interest. The only purpose of this law is to discriminate. And you cannot be going out and harming politically unpopular groups and have the law upheld even under rational basis, is what he's telling us. Now, this doesn't happen very often. Again, it happens with disability, and it happens with sexual orientation, that we have rational basis with bite. I will end on this. Before we created, the last category to be created was intermediate scrutiny. And who is that used to protect more than anyone else? Women, right? Discrimination on the basis of gender, okay? In the 1970s, before the Supreme Court created intermediate scrutiny, it was deciding gender cases on rational basis with bite. It was finding discrimination. It was saying, the laws were unconstitutional, but it was using rational basis. Finally, it got around to saying, you know what, this is crazy. Women have been discriminated against for all of civilization. It's an immutable characteristic. You're either born a woman or a man, or whatever else. It's an immutable characteristic, and we're going to give enhanced scrutiny, so they created intermediate scrutiny. They have not done that for disability. They have not done that for sexual orientation. They continue to use rational basis with bite, okay? All right, guys, we'll see you on Thursday.
I don't want to get in trouble. No favoritism. Here's my little Christmas tree.
Don't bring it to the Allegheny County Courthouse, okay?
Okay, I won't.